welcome all of you very humbly. And so we have with us very gracefully Mr. Om Prakash Ilanti, sir. He is Senior Advocate, Madras High Court. He will be discussing with us today the efficacy of insolvency proceedings for operational creditors. So it's a very technical topic in itself, and I know that everyone will have to go back to it later on. We'll upload the video to YouTube also, which will happen in about 2 weeks' time. So a little more about Sir. Sir is a first generation lawyer. So this is definitely something which I have been personally looking forward to, since I also come from a very similar background, and I know most of my friends and family also, like people whom I know, they are facing lots of challenges, but Sir is definitely that shining light who inspires us and who shows us that, you know, even though it will be a very different way for us, it will be not something which is quite evident to us right now, but it will be there, like if we keep practicing, and as Sir himself said, that if we fix our mind to it and if we just keep going after it, we will achieve it. So Sir is practicing in banking laws, business laws, corporate laws, and he's primarily a civil practitioner. He has been practicing since 1992. And so another interesting thing about Sir is that he started practicing in the Honorable Supreme Court after 10 years of his practice. So all the people who have that doubt whether if you should immediately go and intern with any Supreme Court advocates or something, so this is definitely one very important learning curve, and you can feel relaxed. So along with that, Sir also propagates and promotes a healthy lifestyle, and he says that sports are very important. He himself is a very active player, and he participates in the advocates cricket teams also. So 2 days ago, there was this cricket tournament which was organized, and Sir was a part of the Attorney General's 11 cricket team. And maybe Sir can just give two words on that before he starts the session today. And along with that, Sir, I welcome and I humbly hand over the class to you, Sir.
Thank you very much, Mr. Keshav. It was so nice of you of having said so many good things. It's really interesting to note that when we have sessions which actually helps in people learning things, more than any other thing, as a legal professional, we need to always have it in mind that till the last day, there is never a time where we can say that I have learned something. It is always a learning process. Be it a student of law, be it an young junior practitioner in the bar, or be it a seasoned lawyer, or be it a seasoned senior advocate, whoever it is always a learning process. Law is such that the more you learn, the more you get enlightened, the more you learn, the more you get into a kind of a wisdom where you can look at things in a larger perspective. So in that process, whenever I get an opportunity where I can have some learning process, where I can share some thoughts, which ultimately also helps me to empower myself on a particular subject, I eagerly agree to such opportunities coming forth. And it is one such thing today that I am midst of you to speak on a particular subject and to share my thoughts, as well as have it as a discussion session, so that we will have the sharing of thoughts among ourselves. Thanks once again for the team Vestralex, which actually helped this possible for today's Sunday morning session. I welcome each one of you. And going into the today's session, even before I get into the today's session, as Mr. Sharma wanted me to say a few things about it. He had introduced me, putting it across that I am the first generation lawyer. After having taken up my law course, it was not looking back at any point of time. The day I joined my law college, I had only one thing in focus, that I should practice as a lawyer in the High Court. You must be knowing that as far as Madras, Chennai is concerned, you have the law college very next campus of Madras High Court, which was in the past. Today that has changed. In fact, today the law colleges have been moved out from the High Court campus, and it is spread out in different places. Earlier point of time when I was doing my law, the law college was part of the High Court campus. It is just a next door. So the moment I stepped into my law college, I had my visions of only looking at being a successful lawyer in the campus next door, which is the High Court. Then after having completed my law, I went into my practice. In fact, during my law days itself, when we had only half a day of session, half day of classes, the other half day I used to spend my time in the court, just trying to put a foothold in the chambers of a lawyer. So be there and try to observe how things move out. So that is how it started off. Then having come into the profession, I had focused myself only to get to the best of the profession. So as he said, there had been a travel when I had practiced in the City Civil Court at Chennai, then High Court. Then of course I had the opportunity to step into Supreme Court. So today, after having been designated as a senior advocate, I have this opportunity of appearing pan-India in various forums, judicial forums, courts, say it high courts, or you look at tribunals, appellate tribunals under the special statutes, so forth. Then the other interest which I would just only share with my friends in the group is that I have a kind of interest of keeping myself fit at all times. So I do a lot of running exercises or running activities. I participate in this so-called marathon events. So many events you will find, though it is said as a marathon event, it will be a 10 kilometers run or a 21 kilometers run, though the marathon is supposed to be 42 kilometers. So over the period of 10 years, I have done that, participated in very many events which is possible. So it keeps myself active. Then I do a few cyclings here and there, times when I get to travel. Then I play cricket. That is primarily to just be part of this advocates group at Chennai, where we have an annual event of a cricket match between the Chief Justice 11 team versus the Advocate General 11 team, where judges are part of the Chief Justice 11 and advocates are part of the Advocates 11. So we had a 5th edition of that tournament yesterday, which I was sharing with Sharma. I had been part of it for last all 5 years. So this is how as regarding my personal thing. Now coming back to the topic, because we have a very short time, I don't want to waste whatever expectations you have on getting into some knowledge about the topic. Now, Insolvency and Bankruptcy Code 2016. As you all know, this has been one very, very interesting piece of legislation, which in fact changed the entire landscape of litigations over these last few years. Because what was interesting is, though the enactment came into place in the context of consolidating the winding up or liquidation or insolvency laws, be it the SICA or be it the your Provisional Insolvency Act and Presidency Towns Insolvency Act or the Companies Act, where as regarding corporates, as regarding partnerships, individuals, you had different insolvency legislations governing the field. So it came in a context of consolidating all those things and providing one complete code. Now it also, the act was enacted in the context that there was a lot of discussions as well as committees which went into in the context of huge non-performing assets building up on the financial sector. Banks were feeling a pressure of increasing non-performing assets in terms of loan recovery being very, very dismal. You had earlier the DRT Act, which came in to provide a specialized tribunal for the banks and financial institutions to ensure a recovery by way of early process instead of the long-drawn court battles. Then, having not found much success in the RDB Act, you brought in the Surface Act. The Surface Act was supposed to hand over the metal to the creditors, enable them to enforce the security interest without the intervention of court. So instead of you going to court and establishing your debt, then getting a decree, and in the process of executing the decree, you enforce the securities, bring it for sale and realize. Now that was changed. That entire situation was changed by the Surface Act, where there was deemed to be a debt, and the moment such loan account being classified as a non-performing asset, the law enabled the secured creditors to enforce the security interest created in their favor to secure such outstanding dues. So that law came into place, and whatever challenges for the enforcement was before the DRT. And after a period of time, it was still felt that the required results are not being there. So therefore, in a context of huge build-up of non-performing assets, as well as in the international arena, there was a requirement of ensuring a speedy mechanism in the context of ease of doing business. You had a global index of countries being pointed out as to who is rating better in the ease of doing business. So that became one more triggering point, so that you have a better ease of doing business. Now, when we speak about ease of doing business, what they look at is that any establishment of a corporate, of any establishment of a business enterprise, and if there is difficulties, is there an exit route? Is there an easier exit route? Or is there an hassle-free mechanism of bringing to an end of such enterprise or such business endeavor? So this was the context as far as the ease of doing business. Now, with all these things, the committee suggested that you have a unified code, namely the Insolvency and Bankruptcy Code. Now, two major things or two important aspects which you can see. Any law, you look at what is the statement and objects. You look at what is the background in which this law came into force and what is that it seeks to achieve. Now, in that context, the Honorable Supreme Court has pointed out that the primary objective of Insolvency and Bankruptcy Code is that the maximization of assets of a corporate debtor. If there is a kind of an insolvency situation in an enterprise, be it a company, be it a partnership, or whatever it is, what is to be looked is a maximization of the value of assets, and for which you need a process to be worked out. Then what it tried to achieve is that you balance all the interest of stakeholders. So these were two important things which they said that this is sought to be achieved by the code. One is maximization of the valuation of assets of the company, and second one is the balancing of all the rights of stakeholders. So when you speak about stakeholders under the Insolvency and Bankruptcy Code, or in a general parlance, when you speak about an enterprise or a corporate or a business endeavor which comes about by way of proprietary concerns or partnership concerns, there you look at a situation of the maximization of valuation of assets, or who are the stakeholders who will be involved in it. Now, when we look at stakeholders, primarily you may have to look at the promoters, the person, the entrepreneur who brings in his idea of establishing an enterprise and getting into a business, in the process develop the economy. So therefore the promoters, the stakeholders. Then you get into the financial stakeholders in terms of banks and financial institutions who contribute for the development of this enterprise. Then you have the other category of people who keep the business entity afloat in terms of providing services or supplying goods to them, and the customer base which is part of a business enterprise. So the third category of a stakeholder will be the person who is involved in the business enterprises being kept afloat, namely persons who provide services, who provide goods to the enterprise. Then you have a category of workman, the person who sweat to make the enterprise really get going, the workmen and employees of the concern. Then you have the other stakeholders in the context of either statutory bodies or government authorities who have a kind of fiscal policy, who either bring in a system of regulating affairs, bring in a system of granting permissions, licenses to carry on activities, as well as tax the unit in terms of whatever turnover is being made. So therefore, you have these government agencies, be it the tax authorities, be it the state promotional industries promotions authorities, be it the regulatory bodies, who all have a say as far as a business enterprise is concerned. So apart from this, you may have the other category, which will be the last of category, will be the either persons to whom the enterprise had carried out something, who are basically customers from whom there is receivables to be received. Now, why I say the last category is that somewhere you will also find that these category of people also step in as a stakeholder, because there may be cases where they give advance for the corporate, for the business enterprise to carry on its activities. So summing up, you look at a vast area of stakeholders. Now, when we speak about the stakeholders, which is one of the objectives, the maximization, other than the maximization of assets, it is the interest of all the stakeholders to be met, seems to be objects of the code. Now, having said that, you look at the third stakeholder, namely the creditors. Now, in that, as far as the Insolvency and Bankruptcy Code is concerned, it brought in a new categorization. What we have seen over the period of time or over decades is that you have either a creditor being termed as secured creditor or unsecured creditor. So beyond that, whether it is a person who has lent money or whether it's a person who has rendered service or delivered goods to a corporate, was always a category of creditors. Now, within them, there would have been other things. Let us not travel much into that. Having said this, the Insolvency and Bankruptcy Code brought in a new concept of differentiating these creditors. That was in the context of setting forth a new parameter, namely financial creditor and operational creditor. The code defined who is a financial creditor. The code defined who is an operational creditor. The code defined what shall be a financial debt as well as what shall be a operational debt. So this was the new area which the code brought in. And there should be some understanding or some kind of thought process which had gone into while they differentiated these creditors as financial creditors and the operational creditors. If you get into some detail of this in terms of how the legislation has taken shape, in terms of whatever committee reports which were the basis for the legislation to take a shape, you will find that there had been a lot of emphasis on what is the role to be played by a financial creditor as well as operational creditor. So for today's session, we are concerned about the operational creditor. Now, having said this, I will now try to travel on a very fast manner as to the outline of this code. Now, ultimately, under the Insolvency and Bankruptcy Code, what is the process which has been contemplated? Now, the code seeks to address all insolvency situations. Addressing, the code ultimately looks at a resolution that the company can get going. The code looks at a process by which the company is put back on the rails so that it does not get only a means of liquidation. Now, this you can look into in the context of what was the earlier regime. For example, if you had a winding up petition as against a company under the Companies Act, the moment a winding up order is passed, what was looked at was only the liquidation process. What was looked at, any stakeholder will have a claim before the liquidator, and as the liquidator ultimately liquidates the assets, he is required to share the dividend, or he is required to pay the dividend out of the liquidation estate or the realization from the liquidation estate to all these creditors. Then take the case of individual insolvency, where again you will find any insolvency which was triggered was only resulting in a bankruptcy situation and ultimately on the liquidation for the interest of the creditors. Now, what was earlier said, earlier regime which spoke about insolvency situation is that an insolvency situation was sought to be addressed to ensure that the body of creditors' interest is taken care. They don't want an insolvency situation to prolong so that more creditors are at stake, or that the creditors' interest in terms of whatever securities being created or assets being available for the purpose of liquidation should not be in jeopardy. Now, a shift from that as far as Insolvency and Bankruptcy Code is that it primarily seeks to address a resolution, and it sets out a timeline by which it can happen. Now, getting into the framework of the law, as you would have seen the Insolvency and Bankruptcy Code, it gets into various parts. It speaks about insolvency of corporate persons, namely the corporate debtors, companies which are involved, and the LLPs which are involved. Then you have a separate part as far as insolvency of individuals. Then this code also brings in concepts which were essential for the purpose of regulation. So therefore, a regulatory authority in the nature of IBBI regulatory authority also being provided with powers for bringing in regulations in the nature of subordinate legislations. Then you have professionals who are part of this insolvency process or who are part of the objects which is sought to be achieved by the Insolvency and Bankruptcy Code. So they are called as resolution professionals. So one part of the code deals with who can be a resolution professional, and agencies which can recognize these resolution professionals, agencies which can empower, register, and periodically enlighten this group as the resolution professionals to support the cause of the functioning of this code. So this is a wide framework of the law. Now, in this framework, what you look at is that there is a situation of initiation of this insolvency resolution. So the code provides for a mechanism by which who can bring it for the purpose of initiation. So you identify an insolvency situation, and having identified an insolvency situation, then you commence a process by which the insolvency resolution should start. Be it corporates, which is called as corporate insolvency resolution process, namely the CIRP, or if it is individuals, again in insolvency process, which can take it to the bankruptcy situation or a new life to be carried forward. So this is how it has to be done. So there is a process. Now, in this process, for this initiation, the code recognizes an adjudicatory body called Adjudicating Authority, which is the National Company Law Tribunal, NCLTs. Then you have an adjudicatory mechanism in terms of appeal provision provided to the appellate authority, a further appeal to the Supreme Court. Now, apart from all these things, the code also builds within in various aspects as to the process in the CIRP, identification of various stakeholders' rights as well as claims to be adjudicated, claims to be looked at. And the process is also driven once an insolvency resolution process commences, namely CIRP commences. It is driven by a committee called Committee of Creditors. Now, what the code provides is this Committee of Creditors will be constituted by the financial creditors. So you would have looked at the first situation when we speak about an operational creditor. The code gives a primacy to the financial creditors to be part of the Committee of Creditors. So this is a framework. Now, having set out this, now let us look at the topic of the day. What we are looking at is the efficacy of the insolvency proceedings for the operational creditors. Now, if it had stopped with efficacy of insolvency proceedings, it has got a wide area and it has got a lot of things to be looked at, very many positive situations, very many critical areas which we can also have. But having said that, for the operational creditors, it is actually a real challenge which we have to look at. Now, when we say about efficacy, what we actually mean, efficacy is the end result or the object which is sought to be achieved. In today's parlance, if you want to say what efficacy would mean is that if a vaccine is administered, what is the result it will give in an ideal conditions? This is what is the pandemic situation which we are looking at. So vaccine has become more important today. So likewise, in an ideal situation, in a given framework, in a given process which the code seeks to carry forward and ultimately achieve, what is the efficacy which we are looking at? And that efficacy is to be looked in the context of operational creditors. There is enough of jurisprudence on this subject in terms of judgments of various high courts, NCLT, NCLAT, and Supreme Court. When I say high court, it is very minimal. You have the jurisprudence which has evolved only from the NCLTs being the adjudicating authority and NCLATs being the appellate authority, and then the Supreme Court being the appellate authority recognized under the code. Now, as far as the operational creditors are concerned, what we can look at is that what is the role which the code prescribes for this operational creditor. To understand what an operational creditor would be or what is the operational creditor stakes would be, you may have to look into the provisions. Please look into the definitions under the code. I'm not going to read through or I'm not going to take it through because it may not be required within this short time. And I will only leave it to you to have a further process of reading through yourself. Please see what the definitions are there. At section 5, you have a definitions as far as corporate insolvency is concerned. Section 520 speaks about operational creditor. 5 subsection 21 speaks about operational debt. It is very, very categorical here that it says operational debt is a debt which arises on account of rendering of services to a corporate debtor or supply of goods. Now, again, on this, the jurisprudence has traveled. You have one of the latest judgment of Supreme Court, which is reported in 2022 SEC Online, SC 142, in the case of Consolidated Construction Limited versus Hitpro Energy Solutions. Now, it gives a lot of room as regarding this definition of an operational debt. Then a person who is entitled to recover an operational debt becomes an operational creditor. At the first instance, let us see what is the role which is assigned to an operational creditor under the IBC code. Primarily, you can look at that the IBC code also enables an operational creditor to initiate a corporate insolvency resolution process. So there is an enabling provision. So as far as the process of initiating the insolvency, what is seen is that the operational creditors are also placed on par with the financial creditors. Like a financial creditor is enabled to petition the adjudicating authority to initiate a CIRP, an operational creditor is also enabled to initiate a CIRP. Now, having said this, we need to look at two important aspects. One is, as far as the insolvency and bankruptcy code is concerned, there is a very big shift from what had been in the earlier regime. The shift being that under the earlier laws, you had a debtor in control of the enterprise throughout the entire process. Even in cases of winding up, after the winding up order, the liquidator will take charge of all the assets, but never he would be running the company. So it comes to an end, then it goes to the hands of liquidator, then it goes into the issue of liquidation. Now, as far as insolvency and bankruptcy code is concerned, the shift is that instead of the debtor being in control, the code prescribes that the creditor will be in control of the situation and creditor will drive the entire insolvency. That is where, as I said, it is under the directions of the COC, the Committee of Creditors. Now, the debtor is dispossessed of whatever right he has the moment a CIRP is initiated. Now, this is one aspect which we have to look at. The second aspect is that the very driving situation as far as insolvency and bankruptcy code, be it identifying the insolvency situation or commencement of the insolvency process or further taking forward to the resolution, the most important terms which are looked at is the debt and default. When we speak a lot about insolvency or insolvency resolution or insolvency situation, today the law doesn't look at an ability to address or an inability to pay a debt. That was what was seen as an insolvency situation under the earlier regime. Today, what is looked at is that there may be a capability, there may be an ability for a corporate to carry on to address all its debt situation. But still, if there is a debt which is in default, that triggers the insolvency and bankruptcy code. That enables the creditor, be it financial or be it operational creditor, to initiate a process of the CIRP. So therefore, debt and default is the driving factors. Then debtor being dispossessed and creditor being put in control is the driving force. So if this is said so, what we have to look at is what will be the efficacy as far as operational creditors are concerned. As I said at the first instance, operational creditors are also treated on par with the financial creditors in initiating a CIRP process. But you would be aware that there is one small situation which is differentiated. In cases of financial creditor, they are entitled to file a petition before the adjudicating authority by invoking Section 7. So there is no further requirement. There is no requirement of a notice being served or somebody being called upon to pay the debt and thereafter approaching the adjudicating authority. But in case of operation creditors, Section 8 of the code at the primary stage requires an operation creditor to issue a notice of demand. Now, at that stage, there is a scope which is left to the corporate to dispute this claim, which is part of the notice being sent. So they may point out that there is a pre-existing dispute on the claims being made. And if that pre-existing dispute is brought out in the nature of pointing out an existence of a suit and arbitration proceedings, or by virtue of any communications, if you are able to show that there is a pre-existing dispute, then it becomes a questionable claim. Now, if no such situation is brought forth by way of reply, and if the debt is not paid within 10 days, now this enables an operational creditor to file a petition under Section 9. So this is how the process proceeds. Now, once the CIRP is initiated, where do people stand in terms of financial creditor as well as operation creditors? Now, all of them are required to make their claims to the insolvency professional who takes charge of the corporate debtor and drives the corporate insolvency resolution process. Now, even in individual insolvency, which is not fully notified as on date, the insolvency professional calls for all the claims and he collates and he takes it forward. But procedurally, there are something which is different as far as individual insolvency is concerned. Now, coming back to the corporate insolvency resolution process, all claims are required to be filed. Now, operation creditor is also required to file, but you have different forms. If it is a financial creditor, you have a separate form. If it is a operational creditor, you have a separate form. Now, the insolvency professional, after having received this, where does he place people? As I said, financial creditor gets a primacy in terms of being part of the COC being constituted, whereas operational creditor, at the most, if they constitute more than 10%, will have a right to participate without any vote. This is what the code specifies. Then entire process of CIRP in terms of resolution is driven by the COC. So therefore, what you will find is that an operation creditor is somewhere being left out in the process. He doesn't have a voting right. He doesn't have any say as far as what the COC drives in considering a resolution in terms of expression of interest being called for, and anybody submitting a resolution plan which is envisaged under the code. Now, post that, what is required to be looked into is the next stage where the operational creditor has something is in the liquidation process. Suppose the code contemplates that there should be a resolution plan called for, considered by the COC, and if it is found to be viable, then the COC takes it forward by way of an approval in the COC, and it is further taken to the adjudicating authority for an approval. Now, in this process, the operational creditor doesn't have a big say. Suppose if this is not happening, the resolution plan is not forthcoming, or the resolution plan is not found to be viable by the COC, or the resolution plan is not looked at in terms of whatever they are proposing for the resolution of the corporate debtor, it leads to a liquidation. The second situation of liquidation is that if the timelines are not met, this also leads to a liquidation. The third situation is that if the COC members by themselves pass a resolution that there is no possibility of resolution, then they can put it to a liquidation. So in all these stages, it comes to liquidation. Now, when it comes to liquidation, the code speaks about a liquidation estate and the liquidation estate being liquidated for the purpose of realization, and post realization, the distribution which has to happen, which is under Section 53 of the code. Now, this distribution is said to be a waterfall distribution, waterfall mechanism, because again, there you will find the financial creditors are given a primacy. They first stand to recover their dues, then it passes on to the workmen employees, then it passes on to the operational creditors, then it passes on to the other stakeholders. This is what is the waterfall mechanism under Section 53. Now, having said that, one of the objectives which the code seeks to achieve in terms of what Honorable Supreme Court said is that the safeguarding of interest of all stakeholders. Now, how it is sought to be achieved? The code, by certain provisions, as well as the regulations of the IBBI puts forth the tone as to the manner in which the COC is required to consider the claims of other stakeholders. That is where it had been set forth that either in the resolution or in the liquidation, if the liquidation value is such that the operation creditors will also stand to gain something, that will be at the first instance to be satisfied. So therefore, to the extent of what the liquidation value, if it is able to provide a realization for the operation creditors, they get a primacy at that stage. So other than that, if suppose the liquidation estate is far less even to address the financial creditors, the operation creditors get lost. Now, as regarding the approval of the resolution plan, when it is taken up further before the adjudicating authority, then to the appellate authority, you have a lot of judgments on the point to drive the situation that it is all at the instance of the financial creditors, it is all at the instance of the COC, namely the Committee of Creditors. And the terminology which they have used is that commercial wisdom of the COC. So the Honorable Supreme Court said, what ultimately matters is the commercial wisdom of the COC. Having said that, the Supreme Court also emphasized the point that the COC is required to consider the interest of all stakeholders. And when they said the interest of all stakeholders, they had also pointed out which will be in the context of the resolution and the maximization of the value of assets of the corporate debtor. So looking at that, the requirement would be that the interest of all stakeholders, which primarily will be the operation creditors, to be looked into. So this is on the initiation and the process which is there. Now a considered case where a resolution plan is taken up for consideration and the COC approves. Do the operation creditors have any say in the matter? Is one area which you have a lot of judgments on the point. Initially, there was a travel in the sense that the operational creditors' stakes also have to be considered, and subject to what the COC decides in its commercial wisdom, it has to address the concerns of the operational creditor. But over the period of time and with the march of law, this seems to be have lost somewhere in the process. A question of equitable distribution or non-discrimination and equity being ensured came up for consideration in many matters. And one of the most important judgment on the point is the case of the SR Steels, reported in 2028 SCC 531, where you will find there was a huge clash of interests as between the financial creditors and operational creditors, because the resolution plan which was submitted in the case of SR Steels had proposed a substantial payment to the operational creditors. Because in many a case today, if you have a statistic drawn upon after the IBC came into place and the resolutions which had happened or the liquidations which had happened, you will find there had been lot of realizations by the financial creditors and lot of losses suffered by the operation creditors. That is what is fact as it is glaring on the face. In terms of realization, the financial creditors stood to gain, the operational creditors stood to lose. But in case of SR Steels, the plan in fact proposed that there will be a payment to the operational creditors also. Though it claimed as substantial, it is only about 20% of the claims admitted. That went into question in terms of various financial creditors raising issues. And among the financial creditors, you had a tussle as between the secured and unsecured financial creditors. So when this came up before the appellate authority, a kind of a primacy to the operation creditors was sought to be drawn. The appellate authority, in fact, made an adjustment and said that an equitable distribution is required to be made by recognizing the claims of operational creditors at the sacrifice of the financial creditors, and it wanted the resolution applicant to work on those lines and the COC to consider. But ultimately, when the matter went to the Supreme Court as a challenge to this NCLAT order, it was reversed. The Supreme Court considered various aspects. Now, what was interesting is that at that point of time, there was an amendment which was also brought in, which said the resolution plan being considered by the COC and approved by the adjudicating authority, while taking into consideration of all the claims of the stakeholders, may not have a view as regarding fair and just and equitable distribution. The code emphasized the point, the moment it is done by the COC, a resolution plan is considered and approved, considering the claims of all stakeholders, including the operation creditor, it has to be treated as fair and equitable. Now, when it came to the Honorable Apex Court considered into various aspects, and it, in fact, while addressing the issue of equitable distribution or equity to be ensured, the Honorable Supreme Court said that unequals cannot be treated as equals. So they tried to draw a distinction that as between financial creditors and operational creditors, there is an unequal position. The Honorable Supreme Court, starting from the decision of Swiss Ribbons and further traveling up to the SR Steel and thereafter, had in fact held that the viability of a resolution or a viability of the corporate debtor being kept as a going concern and revived back will be in the hands of the financial creditors. The Supreme Court held that the financial creditors will be in a better position and they have the expertise to assess the viability. Therefore, it will be they who will do it. Now, when it came to the operational creditors, the Honorable Supreme Court said the operational creditors operate entirely in a different regime. They may not know what the corporate debtor is capable of or what the corporate debtor's strengths are. So, having said this, the Supreme Court said that whatever the Committee of Creditors decide in their commercial wisdom has to be held. The appellate authority and the adjudicating authority's role are very limited to the extent what has been provided under section 30, 31, as well as 61 of the code. Now, there they said, in terms of an approval of a resolution plan, the adjudicating authority or the appellate authority does not have any jurisdictions, the so-called equitable jurisdiction. The Supreme Court said in terms of the legislature, the code's provisions, it is very categorical that you can only examine within the framework which the law has laid down, and you cannot exercise any other jurisdiction beyond that. So this had been the situation as far as resolution is concerned. No, an overall analysis of the entire situation as far as these operational creditors is concerned. Now, to sum up, what do we say? Does the efficacy of the insolvency proceedings for the operational creditors achieves what the operational creditors require to achieve? Or does it achieves what the code seeks to achieve as an object? Or where do we stand? Now, on one hand, you will have a very big paradoxical situation. On one hand, the courts have repeatedly said that the Insolvency and Bankruptcy Code is not meant for recovery. Now, on the other hand, you will ultimately see from the basis on which the legislature came into place and driving force before as far as the process in the code is concerned, and the end result which IBC puts forth, as of now, what can be seen is that it is mostly the recovery which mattered. Ultimately, the financial creditors have been driven on the point of ensuring recovery and wiping off their non-performing assets. So this, according to me, seemed to be a very big paradox. On the one hand, saying that the code is not for ensuring any recovery and it is not a recovery proceedings. On the other hand, the end result always looked at is the recovery. Now, having said that, I had my own deep thoughts on the subject to look at what we are. Now, there is some jurisprudence and there have been some critical articles from law students, academicians, lawyers, everybody who had said that there had been a very poor treatment as far as operational creditors are concerned. Every other critic would point out that the operation creditors stand to lose as far as an IBC proceedings are concerned. And in fact, suggestions have been made that the legislature may have to bring in amendments to address these issues. So leaving that apart, leaving that as to what has been critically said, my thought process went into two areas. One, the Insolvency and Bankruptcy Code today has brought in a very big shift in terms of business being carried out. Today, every business organization is conscious of the fact that if I have to ultimately result in a default of my existing debt, I am likely to face a situation of losing the business. I am likely to face a situation that the enterprise may continue, the insolvency situation may be resolved, and the company's continuity will continue, but in a different hands. It is not going to be the promoters who are going to have the same cakewalk. So this situation has set in. Now, having said this, I also need to point out, when it is a question of stakeholders, the promoters being considered as stakeholders, and promoters being considered in the resolution plan, as well as either it is approval post-resolution, where I said that there is a situation of these promoters losing the business enterprise, I need to point out enough mechanisms have been built in by way of amendments to ensure the protection of MSME. When it came to the question of MSMEs, the Supreme Court as well as the legislature stepped in and ensured whatever ineligibility which has been put forth for a resolution plan to be submitted, in case of MSME, there was an exemption which was provided. So that is one area of it. Now, leaving that, as I said, the code now has brought in a kind of entirely a new discipline into place. Now, in this discipline process, understanding the business for a moment, you can always see a financial creditor who lends money will definitely know the entirety of a business enterprise. He may examine the entire thing. He may do his due diligence. He will find out what is the lendings which the enterprise has done and what is the equity which has been pumped in. Then he will also look into what is the proposals or the projections which are made. So therefore, a financial creditor stands in a way. Now, as far as operational creditors are concerned, it is not the case in all times. There are operational creditors who may not even understand what is the business is. He only looks at one requirement of a goods which is sought for, he may deliver that. He may look at one area of services which is sought for, he will deliver it. So he will not have an opportunity, or he is not required to find out whether the entire business enterprises is today feasible, today whether it can get along, whether it is strongly placed, what are the financials, all those things are not there. So this is what is the financial system. This is what is the business system which is there. Now, once the IBC code has come in, I find, or my understanding or my driving force would be that this situation would change. Everybody will today look at whether I'm really doing a service to an organization which has its own strengths, whether where I'm supplying my goods to a person who can really honor his commitments. So this is one thing, a kind of discipline which may set in, which may be an efficacy as far as insolvency proceedings or an efficacy under the IBC code to be achieved in a long term. Now, second aspect, the IBC also brings in a kind of utility information services. Now, the information services which the IBC speaks about seeks to bring on record in a transparent manner as to every debt and default of a company. Now, when we register yourself, even an operation creditor, if there is a debt, he is required to register with this information utility. Therefore, more of a transparency is now setting in. In that area, there is a very proactive role which an operation creditor can play. He will be today aware of what are all the debts of a company before he makes a supply or before he makes a service to be rendered. Then what will happen is that you have a system which is falling in place, though the system in a time-bound manner will take care of certain aspects which had been traditionally the reasons for defaults in this corporate scenario. So this is one area which you can. Then more interestingly, what I find is that operational creditors have been a triggering force in terms of initiation of CIRP. You would have seen in major cases and huge cases in terms of statistical data, many a times the CIRP is commenced at the instance of an operational creditor. It is only a limited cases where the financial creditors or the banks have stepped in by way of Section 7 proceeding. So it is the operational creditors who step in initiation. Therefore, today, the efficacy is in terms of you have a threat. You have a hold in your hand to ensure that the corporate commits to itself in terms of repayments, or the realizations to be made by the operation creditors are streamlined. Now, in addition to this, what I find in terms of Section 8 of the code is that the operational creditors can also be a driving force. Today, you have an opportunity of putting the corporate debtors in place by making your demands as and when a default happens. Now, this has to be seen in the context of what we have gone through traditionally. In our earlier regime, in our traditional way of going for recoveries, the moment a legal notice was issued or a notice of demand was issued, you would have heard that people will say, I am happy you have initiated something, please go ahead. Because that was in the context that a demand notice, the moment it is served, what it will result is that you may go to a civil court for recovery. The moment you go to a civil court, I have all my defenses, and dehorse whatever is the defenses. A civil court proceedings will take you to 2 years or 3 years. I have the benefit of money, I will carry on my business. Now that scenario changes. Today, if there is a demand notice in terms of Section 8, there is a threat for the corporate debtor. Now, corporate debtor either falls in line to ensure that the default is addressed, payments are made, or if he has a real concerns of dispute, he has to come forward. He cannot keep quiet and at a later point of time say that I had these issues on the quality or I had these issues on the service being rendered. So all those things have to be addressed. Now, what is interesting is that this triggering in terms of Section 8 by issuance of a notice is again time bound. You have only 10 days to reply. The moment he goes to the NCLT for initiation of CIRP, there is again a time bound. So this area which I look at is a kind of an efficacy as far as operational creditors are concerned in the insolvency proceedings. But having said this, I am conscious of the fact this is only on the initiation. Now, post-initiation, as I pointed out, there had been enough of criticism which had come forth, either on the judgments or on the provisions or the amendments which came in. Now, all point out to the factor that there is a very, very bad treatment which has been meted out to the operational creditors. So having said this, on the topic, I rest with this. I think you had been benefited. You had a good time enjoying it. I am also conscious of the fact that this is a very dense subject and it may require sufficient time on each aspect to be dealt with. I only tried to do my best to put forth whatever I can in the limited time which I am able to spend with you. Thank you all. Thank you for having participated in this session. I will now invite any comments or any queries, and I will be ready to answer that.
So just very briefly, I want to first of all thank you for extensively and to the point taking us through the entire code, right from the history and bringing it to the point of what exactly the efficacy is it that you want to convey, that it is only the threat that the operational creditor has. And sir, I think I'm getting goosebumps while saying this also, sir, but this was absolutely a wonderful and entirely unexpected manner in which I have personally been able to gain the real efficacy of IBC for operational creditors. So along with that, any questions for sir may kindly be anything that you want to put across to sir, please, because we have very limited time, so I'll request everyone to not hesitate and ask.
Good morning, sir.
Yeah, good morning.
So I had a question regarding Section 8. As you said that the demand notice is questionable. If like the suit instituted previously, is it necessary supposed to be by a creditor, operational creditor, or anybody who has filed a suit for claims or a proceeding for claims can make the claim questionable?
No, it is not required. In fact, Initially, the Honorable Supreme Court said that by the provisions of the code, it only meant that there should be a pre-existing suit or an arbitration proceedings. But Supreme Court stepped in and said, when you find that there is a dispute which is worth consideration, dehors whether there is a suit or arbitration proceeding, it will still be considered as a dispute, and the NCLT had a scope of adjudication to decline such a petition. Now, post that, in fact, amendment has come, which now says or. So a pre-existing dispute or a pendency of suit or arbitration. So therefore, today it is not required that a suit or arbitration is to be required. What is required is that to establish a pre-existing dispute. That will be sufficient.
All right.
Okay,
So we, Ms. Jain, I hope that answers your question. Just one final question. If anyone has one interaction, I think only time will be able to comment us right now. All right, sir. So I think everyone has their answers. But sir, I'm quite sure.
It must have been a bit dense subject also. I have tried to squeeze in everything and put
Sir,
across. So,
I've been taking notes. I've made this wonderful.
Whatever questions which comes to you also, you can collect it and send it across. I will try to answer whatever is possible.
Most definitely. And I'll also communicate to everyone that he will be sharing a brief note with us also post the class, and that I will share within the WhatsApp group. So people who are there, they can get it there, and otherwise people can approach us independently.
Please.
So, sir, along with that, sir, we're extremely grateful, and I only know that everyone who is here right now has a lot of processing to do, considering all the information that has so wonderfully been put into our heads. And also, sir, I think one very important thing, which also personally, which I've been able to realize from this particular class, is that there is also this aspect of delivery before the court, of how exactly should we present our cases, and that's been absolutely remarkable. So it's absolutely to the point, and it's really great, sir. We're very, very grateful to you, sir, for having had taken your time out today on a Sunday, and for enlightening us, whatever small bunch of people.
Thank you very much, sir. Thank you.